Resuming debate, the honourable member for Abitibi, Bay James, Nunavik, AU.
Thank you, Mr. Speaker. And I want to begin by repeating what the Minister opened his speech with, but by adding another dimension to it. Yes, it is fine to acknowledge that we are on unceded Algonquin territory, but that's fine to do that. But it's quite another to recognize as well that Ottawa has not been paying the rent in this place. It is unceded Algonquin territory. We also must recognize the second part of that. Mr. Speaker, I want to acknowledge first the importance of this legislation because there's a lot of talk today about nation-to-nation, reconciliation, and so on and so forth. And this is one example of how to get it right. This is one example of how to proceed. The previous bill with respect to environmental assessment in the Yukon, S6, was unilaterally imposed on the indigenous peoples of the Yukon and the Yukon government. That is not the way to go about it. You do not change agreements that you sign with indigenous peoples unilaterally. That is supposed to be done collaboratively. And that did not happen with the previous bill. The present bill, Mr. Speaker, will have the effect of repealing some of the controversial aspects of the previous bill. Let me just repeat some of them. The previous bill would have authorized the Minister of Northern Affairs to delegate any of the minister's powers or functions and duties under the Indian Act to the territorial government. One of the first things we learn in law school, Mr. Speaker, is that that cannot happen. You cannot do it. You cannot delegate powers to another. And it's one of the first Latin phrases that I've learned when I went to law school, delegatus non potes delegare. So you're not supposed to do that. The other controversial aspect, and I pointed to this aspect a while ago in my question to the Minister, is that the previous bill established time limits in environmental assessment. That's problematic because, Mr. Speaker, my constitutional rights have no time limits. Constitutional rights of indigenous peoples cannot be imposed with time limits, and that was one of the other controversial parts of the previous bill. Mr. Speaker, I want to talk a bit about the notion of clarity, the notion of having clear rules under environmental assessment. I've also suggested just a while ago that I'm from the James Bay, Northern Quebec region. The entire area is covered by the James Bay and Northern Quebec Agreement. A special constitutional and legal regime is in place, and the rules are clear under the James Bay Northern Quebec Agreement. This is how development is going to happen in the James Bay territory. So Section 22, which is a highly complex chapter of the James Bay Northern Quebec Agreement, provides for that environmental protection, environmental and social protection regime, where Cree are part of the Board of Environmental Assessment and Review, or the Cree Nation and the Inuit can appoint members to the board. That's true participation in an environmental assessment process. So the James Bay Northern Quebec Agreement, Chapter 22, is the environmental and social protection regime that's provided for under that treaty. A lot of people in the past have said, especially at the beginning of the regime, that this process is too heavy, this process is too complex, and it will impede development in the territory. Well, Mr. Speaker, quite the contrary happened. After 40 years of experience with this regime, after 40 years of experience with these processes that are under the James Bay Northern Quebec Agreement, it hasn't impeded on any development in the territory. In fact, it has even allowed many partnerships to happen between mining companies and forestry companies, hydroelectric development companies, with the Cree and the Inuit in the territory, because the rules were clear. They might be heavy, they might be complex, but when the rules are clear, everybody knows what the rules are, then that is what helps development take place in a given territory. The other aspect that I want to talk about briefly is the fact that this bill was co-developed, co-drafted, I would presume as well, and that does not happen often enough in this place. I also have experience with one of the very first federal legislations that were co-drafted with the indigenous people concerned, and that is the Cree-Naskapi Act in 1984. The Cree-Naskapi Act was negotiated with the Cree and the Naskapi, co-drafted, every article or provision being accepted before even the legislation was tabled in this place. That's what nation to nation looks like, Mr. Speaker. That's how we should proceed with any given legislation that relates to indigenous peoples, indigenous rights, and indigenous status. Mr. Speaker, one of the most important aspects of all of this discussion is perhaps the notion of free, prior, and informed consent of indigenous peoples in any given project. In fact, the UN Declaration on the Rights of Indigenous Peoples contains several provisions articulating the notion or the concept of free, prior, and informed consent. The most general is Article 19, of course, for those who are familiar with the UN Declaration on the Rights of Indigenous Peoples, which obliges states to consult and cooperate in good faith with indigenous peoples in order to obtain their free, prior, and informed consent before adopting and implementing measures or legislation that may affect them. Other provisions of the Declaration set out more specific obligations requiring degrees of free, prior, and informed consent in specific contexts. Article 32, for instance, Mr. Speaker, obliges states to consult and cooperate in good faith with indigenous peoples in order to obtain their free and informed consent prior to the approval of any project affecting their lands, territories, and other resources. That's an important concept that we need to keep in mind every time we discuss legislation in this place, especially with respect to the environment, Mr. Speaker. Article 28 of the UN Declaration establishes a right to redress for indigenous peoples for lands, territories, and resources that they have traditionally owned, occupied, or used, which have been confiscated, taken, occupied, used, or damaged without their free, prior, and informed consent. It's an important provision under the UN Declaration, Mr. Speaker. Article 29 requires states to take effective measures to avoid storage or disposal of hazardous materials in the lands or territories of indigenous peoples without their free, prior, and informed consent. There again. It's an important concept, Mr. Speaker. Article 10 protects indigenous peoples from being forcibly removed from their lands and territories. No relocation shall take place without the free, prior, and informed consent of indigenous peoples concerned, and after agreement on just and fair compensation, and where possible, the option of return. The Declaration provides context to these articles, clarifying that indigenous peoples have suffered from historic injustices as a result of their colonization and dispossession of their lands, territories, and resources, and the intention of the rights in the Declaration will enhance harmonious and cooperative relationships between states and indigenous peoples. That was exactly my point just a while ago, Mr. Speaker. Article 1 states that indigenous peoples have a right to the full enjoyment as collective or as individuals of all human rights and fundamental freedoms. And Article 3 and 4, as partner provisions, state that Indigenous peoples have a right to self-determination, including to freely determine their political status and freely pursue their economic, social, and cultural development, and to the autonomy and self-government regarding internal or local affairs. Mr. Speaker, United Nations Special Rapporteur on the Rights of Indigenous Peoples, as an expert in the field of Indigenous rights appointed by the UN Human Rights Council to examine obstacles to protecting rights of Indigenous peoples, to review alleged violations of Indigenous rights, and to make recommendations on appropriate measures to prevent or remedy violations. The Special Rapporteur has consistently, Mr. Speaker, emphasized the importance of good faith dialogue and meaningful consultation in the aim of achieving consent as the primary objective of the principles of free, prior, and informed consent. The purpose is to reverse historical patterns of imposed decisions and conditions of life that have threatened the survival of Indigenous peoples in the way that the principles of consultation and consent have the objective of avoiding the imposition of the will of one party. Those are important principles, Mr. Speaker, that we need to apply every time we consider legislation in this place. The Minister of Justice already has the obligation, Mr. Speaker, to vet any legislation against the Charter of Rights and Freedoms. We don't have the equivalent as we speak right now for Aboriginal and treaty rights under Section 35. I have a bill, by the way, that will be debated this coming September, Bill C-262, that will fix that. And I'm hoping that I'll be getting the support, the full support of the members of this House. Mr. Speaker, under international law, Indigenous peoples have the right to exercise self-determination. Indigenous peoples have pre-existing sovereignty, jurisdiction, and rights in the right to self-determination in regard to their territories. That must be respected without discrimination or threats of use of force, imposed time limitations, or delegation of authority. When in October 2015, Champagne and the Ashiek First Nations, the Little Salmon and Carmacks First Nation, and Peston Council took S6 legislative changes to the Supreme Court of Yukon, their case stated the changes were inconsistent with their final land claim agreements. Since then, Indigenous peoples concerned have been compelled to negotiate under these false premises. As a result, the Indigenous parties to the negotiations had little or no leverage. In this context, the Special Rapporteur has stated that most consultation processes require key elements in order to be considered free, informed, and in good faith. First, in designing a consultation process, attention must be paid to the implications of power imbalances that may exist between Indigenous groups and the governments engaging in consultation, and if necessary, deliberate steps should be taken to address those. Second, Indigenous peoples, Indigenous groups affected must have full access to information regarding the project, including technical studies, financial plans, environmental assessments, and other relevant documents that the context demands. Indigenous groups may also be involved in the conduct of those studies, and in a language that they may understand. For many years, Mr. Speaker, in the James Bay Territory, Hydro-Quebec provided information only in French to the Cree people that have English as a second language, or Cree as their mother tongue. That was a problem, fundamental. Third, consultations should take place before the government authorizes or company undertakes or commits to undertake any activity related to the project within Indigenous territory or other lands subject to Indigenous rights. In practice, consultation may take place at multiple stages of a project, from its initial proposal through exploration, development, and operation to its closure. Indigenous groups should be consulted from the earliest stages to build trust and cooperation. Starting the consultation process at a later stages often engenders distrust, making agreement or consent more difficult to achieve, Mr. Speaker. Fourth, Indigenous people should be consulted through their own representative institutions, leadership, and decision-making structures. This gives recognition to the Indigenous people's own choices and forms of self-government, thereby according the consultation process greater legitimacy. Bill C-17 has significant meaning for the Yukon First Nations, Mr. Speaker, and regional politics in the far north. But it doesn't go far enough sometimes. But that is the party's decision to go with it. In November 2015, the Land Claims Agreement Coalition, which includes First Nations in the Yukon, wrote to the Minister of Indigenous Affairs requesting the immediate suspension of the previous government's fiscal approach as it is incompatible with their treaties. They requested that the new government develop a proper fiscal approach based on a nation-to-nation relationship. I am pleased to see the Minister responding with this bill as a first step to rectify the imposed changes from the Harper government. However, in addition to the provisions in this bill, the Liberal government must reverse the Harper government's unilateral imposition of a new fiscal agreement on all of the First Nations in the Yukon. Any laws attempting to change the implementation of land claims agreements can only be made with the full and active consultation and participation of the First Nations governments, Mr. Speaker. I want to close by saying that, Mr. Speaker, one of the important roles that we have as Parliament and legislators is to keep in mind our responsibility as parliamentarians. One of the highest responsibilities that we have as parliamentarians is to uphold the rule of law. And upholding the rule of law means respecting the Constitution. Respecting the Constitution includes Section 35 rights, Aboriginal and treaty rights. That's what upholding the rule of law means. For too many years, in fact, Mr. Speaker, for 150 years, the federal government, successive Liberal and Conservative governments have been adversaries to Indigenous peoples and their rights and their status. It is the only group in this country that has received that kind of discriminatory approach. For 150 years, Canada has fought against Aboriginal rights and Aboriginal peoples in this country. We don't know exactly how many hundreds of millions of dollars the federal government spends fighting Aboriginal rights every year. Some say it's about $300 million. Some say it goes up to $1 billion a year fighting Aboriginal rights, the first peoples of this country. And many times, those fights are unnecessary. Even after a first victory, a second victory, a third victory, we still are dragged to the Supreme Court every single time for the last 150 years. And as you start to celebrate the 150 years of this country, Mr. Speaker, maybe we should keep that in mind. That for the next 150 years, we don't need to do that anymore. Because I think if we are truly in an era of reconciliation, if we truly believe what we say when we talk about reconciliation, nation to nation, respect for Aboriginal rights, then those kind of things need to stop. Case in point, the Canadian Human Rights Tribunal, where the federal government is still up against Indigenous children in this country. So I thought it was important, Mr. Speaker, to remind ourselves that our foremost duty as parliamentarians, our foremost duty as members of Parliament is to uphold the rule of law. And that means respecting the Constitution and that means respecting the fundamental human rights of the First Peoples of this country. Thank you, Mr. Speaker.